Hello and welcome to the ICAS Insolvency and Restructuring Conference on Demand session on the Moveable Transactions Scotland Act for insolvency specialists. My name is Louise Laing and I am joined by my colleague Lindsay. We are both senior associates at Brodies, and together we're going to provide you with an overview of the Moveable Transactions Scotland Act and consider how it will affect insolvency practitioners and others working in the restructuring and insolvency sphere. I'll now pass over to Lindsay to give a bit of background to the Act.
Thanks, Louise. So just putting all of this into a bit of context, the Act is the first major reform of Scottish security law, with the exception of the introduction of floating charges way back in the 1960s. And it's taken quite some time to get to this point. Movable transactions were first identified by the Scottish Law Commission, the SLC, as a potential area for reform back in 2005. So we're looking at almost 20 years on from then until the reforms, will actually come into force. And that's because although the Act was actually passed in May of this year and received royal assent the following month, we're not expecting to see the Act be brought into force until the second half of next year. And why this delay? Well, there's a few reasons. First of all, the Act creates two new statutory registers, which the Registers of Scotland have to build, and that work's well underway, and I think we're almost at the beta testing stage. There's rules around the registers that need to be written. It's acknowledged that further consultation on and fine-tuning of is required of certain provisions, including insolvency provisions, which Louise will come on to later. And those aspects of the original Scottish Law Commission's Moveable Transactions Bill, which were removed due to issues around legislative competence, have to be addressed by the UK government. And namely that the application of the Act to financial collateral, and that includes security over shares in a Scottish company, or what we commonly call a share pledge. So why was it felt that reform was needed? In a number of ways, the current law in Scotland, as regards movable property and the ability to create security over movable property, is quite unsatisfactory. What do we mean by movable property? In broad terms, it's anything that isn't heritable or leasehold property, so it's not property relating to land. And movable property can be corporeal, so something tangible such as cars, plant, machinery, whiskey casks and the like, or incorporeal, such as intellectual property, rights to payments of debts, invoices, and rights in relation to shares. And the ability to create security of removable assets in Scotland is really quite impractical and it's uncommercial. And that's due to various requirements of Scots law. The first being in relation to some assets, the need to give notice to third parties to perfect the security, for example, in assignations of rents over retail properties, where there's often hundreds of tenants that require to be notified, or the requirement to actually transfer title to the assets, for example, the transfer of title of the shares in a Scottish company where a share pledge is taken, and also the requirement to take possession of the assets themselves. So, for example, whiskey casks, although there are workarounds which involve third-party custodians holding the assets, or other assets such as vehicles, though again there are workarounds such as hire purchase agreements, etc.
So I'm sure many of you will be familiar with some of the issues which Lindsay has identified and the fact that these can significantly limit the scope of fixed security which can feasibly be taken or granted over Scottish movable assets. Floating charges, of course, remain available to those entities which can grant them, but they don't give lenders the same priority ranking on insolvency that a fixed charge does. As a result, Scottish businesses can struggle to access finance, in particular partnerships and sole traders, which are unable to grant floating charges. And in comparison to their counterparts elsewhere in the UK, they face higher borrowing costs to compensate lenders for the additional risk or the expense involved in putting complicated workarounds in place. The reforms brought in by the Act will modernise and improve the law of Scotland in relation to transactions involving movable properties. They will make it easier and cheaper for Scottish businesses to exploit their assets to raise finance and improve cash flow. Lindsay will now take a look at the reforms in more detail.
Thanks, Louise. So what are the main reforms? The Act itself reforms the current law in three main ways. First of all, it introduces a new form of security that can be granted over Scottish movable property, known as the statutory pledge. Secondly, it modernises some elements of the law in relation to assignations, those are transfers or assignments in English law. And it creates two new statutory pledges as registers, to be set up by the Registers of Scotland, as I've mentioned, and those will be the Register of Statutory Pledges and the Register of Assignations. So looking first at the new fixed security, the new statutory pledge. Pledge is a fixed security under Scots law, and we currently have, under existing law, a possessory pledge, and that requires transfer of possession from the party who owns the property to the person who will be taking security over the asset. The possession requirement means that in practice, we don't actually see an awful lot of pledges used, or where they are used, there are various workarounds in place. So once the Act is brought into force, there'll be two types of pledge available under Scots law. First of all, the possessory pledge, which we've currently got and which requires the delivery of the relevant asset to the secured party, as I've mentioned. And then also a new statutory pledge, which does not require delivery of the asset. Instead, the new statutory pledge can only be created by registration in the new Register of Statutory Pledges. What can this new fixed security be created over? Well, a statutory pledge can be created over corporeal property, so whisky, casks, vehicles, machinery, etc., and also incorporeal property. But at the moment, the only type of incorporeal property that a statutory pledge can be taken over is intellectual property, and that's because financial collateral, which includes shares in Scottish companies, has been removed from the Act. Worth also noting that aircraft and ships are specifically excluded from the scope of the pledge, as these are subject to a separate security regime. Just going back to the point regarding shares in Scottish companies, lenders will commonly take security over shares in one or more group company as part of a security package. And currently, in order to complete that right in security, actual ownership of the shares has to be transferred to the lender or its nominee. So the lender has to be the registered owner of those shares in the company's register of members. And that transfer carries various risks and implications for the registered holder in terms of liability for defined benefits pension scheme deficits, for being a person of significant control, a PSC of the company, and under the National Security and Investments Act 2021, if the company happens to be in one of the designated high-risk sectors. Now, those sectors under the NSIA cover some fairly obvious areas like defence and nuclear, military, but it also covers areas such as energy, so that potentially could cover a large number of Scottish entities operating in the oil and gas sector and the wider energy sector. So the Act does not currently allow a statutory pledge to be taken over shares in a Scottish company. The Scottish Government was of the view that they didn't have legislative competence in that area. And the intention is that this will all be dealt by separate secondary legislation by the UK Government, which will have the effect of making a statutory pledge over shares in a Scottish company competent. So the statutory pledge can be created over future property. The property which is being pledged has to be identifiable, and that can be either each item has to be identified separately, or there have to be an identification of items in terms of them constituting an identifiable class. The pledgor, so the person granting the security, does not have to be the owner of the asset at the time it signs the pledge document. That means that the statutory pledge will be able to be granted over future property. And a statutory pledge, including future property, can be registered even if the grantor does not own the property referred to within it. The pledge over the future property will only be created when the grantor becomes the owner of the assets being pledged. So what does all this mean in practical terms? It means, for example, that whisky stocks or whisky casks will no longer require to be delivered to a third-party custodian for possessory purposes. So security can be created by registration alone. Also means that once that secondary legislation has been passed, it will be competent to take a statutory pledge over shares in a Scottish company, and that will avoid the concerns related to the transfer of the shares to the lender that I've just mentioned. So all those issues around pension scheme deficits, PSC registration, and the National Security and Investment Act. If we move on now to assignations, the Act very much modernises much of the law on assignations and deals with many of the shortcomings of or uncertainties around the current law of assignations in Scotland. The Act also introduces an additional method of transfer of claims by assignation followed by registration in a new Register of Assignations. So when the Act comes into force, an assignation can be perfected by intimation or by registration. So what can be assigned? So it's claims that can be assigned, and claims are defined in the Act as a right to the performance of an obligation, including an obligation not to do something, but it does not include a non-monetary right relating to land or a negotiable instrument. The claim has to be identifiable, whether by reference to each specific claim or by reference to an identifiable class, for example, all of a business's invoices to a certain customer. And the Act very much clarifies a number of the uncertainties around under the current law. What about future claims? Well, currently there is ambiguity under the current law of Scotland as to whether future claims can be assigned, but the Act gives us some clarity here, and under the Act, the assigned claims must be identified within the assignation document, but they need not be held by the assigner, and they need not even exist at the time of signing of the assignation document. Conditional assignations are also going to be possible. There is currently uncertainty under the law in Scotland as to whether an assignation subject to a condition is effective, but the Act clarifies that assignation of a claim can be subject to a condition before the claim is transferred, but that condition has to be specified in the assignation document. So, for example, an assignation could be conditional on the occurrence of a particular date or the occurrence of a particular event, and whether or not it's certain that thing will happen, or the elapsing of a period of time during which something must not happen, and whether or not it's certain that that thing will happen at some point. As for assignations in part or partial assignations, there is uncertainty as to whether those are currently competent and effective under Scots law. The Act clarifies this and make clear that it will be competent for a monetary claim to be assigned in whole or in part. So, for example, that would be where Company A owes Company B, say, £100,000. Company B could assign £60,000 of that to Company C and retain the debt for the rest. As regards method of intimation, there is currently some uncertainty around what type of intimation is valid under Scots law, and the Act clarifies that it will be possible for intimation to be made by way of electronic communication by email or via an online portal. So what do all these chains, what do they all mean in practice? What can we expect to see? I think what we are anticipating seeing is quite a heavy uptake in the new way of registering perfecting an assignation by registration, particularly in situations where there'll be an awful lot of parties to intimate to. Although there may be other reasons why you would want to give notice to those parties anyway, for example, to give new account details for payment. But that is one of the significant changes we are expecting to see once the Act is in force. And on that note, I will hand over to Louise, who's going to talk about some of the implications for insolvency specialists.
Thanks, Lindsay. So what do all of these reforms mean for IPs and others working in restructuring insolvency? Well, first of all, when we turn to finance options, when IPs are engaging with businesses which have identified a funding gap, cash flow issues, or other signs of financial distress, the new Act gives more options for raising finance. For example, if the business has an expensive piece of equipment which it uses in its day-to-day operations, granting a possessory pledge is not an option at the moment. However, once the Act comes into force, a statutory pledge will allow the business to raise finance against that piece of equipment whilst retaining possession of it and utilising it in the continuing operation of the business. We also expect to see a change in the creditor landscape. As Lindsay has highlighted, the Act simplifies and modernises Scots law in relation to transactions involving movable property, removing a number of the barriers and impracticalities and making it easier to grant and take security over movable property. This will make lending in Scotland more appealing and open up the market to finance providers with lending models which Scots law, as it currently stands, cannot readily accommodate without complicated and expensive workarounds. As a result, we can expect to see a change in the creditor landscape, namely the number and identity of those providing finance to businesses in Scotland, the number of creditors holding security, and the type of security held. So down the line, insolvency practitioners are likely to be dealing with more and a wider range of finance creditors and more creditors holding fixed charge security. There will also be implications for diligence in relation to the debtor's assets. Following their appointment, an IP will take steps to confirm the extent of and gather and safeguard the debtor's assets. In addition to speaking with the debtor's officers and employees and reviewing the debtor's own records, insolvency practitioners will check public records to identify assets owned by the debtor. The new Register of Assignations and Register of Statutory Pledges will become additional sources of information for the insolvency practitioner. However, as noted earlier, the Act adds to rather than replaces the existing law. It will still be possible to assign claims either outright or in security by intimation, and to grant a traditional possessory pledge, neither of which will require registration in the new registers. The new registers will therefore not necessarily provide a complete record of transactions concerning movable property for any particular debtor. As Lindsay mentioned, the Act provides for the assignation of future claims and for the granting of statutory pledges over property to be acquired by the grantor. Therefore, questions may arise as to whether claims arising and/or property acquired after the commencement of an insolvency process forms part of or an unencumbered part of the debtor's estate. The Act includes specific insolvency provisions to deal with that. In the case of statutory pledges, the Act is quite clear. The statutory pledge is not created over any property which is acquired by the grantor after becoming insolvent, notwithstanding the fact that such property is identified in the pledge document as property to be encumbered. The Act contains a similar statement in relation to claims of which the assignor becomes the holder after becoming insolvent. The assignation is ineffective in relation to any such claim. However, the Act provides an exception to that rule in relation to a claim in respect of income from property, insofar as that claim is not attributable to anything agreed to by or done by the assignor after they became insolvent, and relates to the use of property in existence at the time the assignor became insolvent. Whilst it is clear from the explanatory notes to the bill that an assignation of royalties and an assignation of rents remain effective on the insolvency of the grantor, the interpretation of income from property will be key in determining the effectiveness of assignations of other types of claims on the insolvency of the grantor. For example, loan repayments under loans assigned pre-insolvency, and the extent to which those claims form part of the debtor's estate in the event of their insolvency. Lindsay mentioned at the outset that further consultation on and fine-tuning of certain provisions of the Act is required, including the insolvency provisions. The provisions which I've just described in relation to the treatment of pledges of future property and assignations of future claims where the grantor becomes insolvent include descriptions of when someone or a business is regarded as becoming insolvent for the purposes of the Act. Now, there was a bit of toing and froing on those descriptions as the bill made its way through the legislative process, and it was noted during the Stage 3 proceedings that there would be further consultation on their terms prior to the Act coming into force. So we'll need to watch this space. When it comes to realisation of assets, there will also be the changes brought about by the Act will also have an impact. It'll impact on how IPOPs deal with realisations. Currently, secured creditors in a typical Scottish insolvency consist of standard security holders and where the debtor is a corporate entity, floating charge holders. Now, whilst an IP will usually seek the consent of all secured creditors to any proposed sale, and discharges of any standard securities will always be required, an administrator has the ability to dispose of property which is subject to a floating charge, as if it were not subject to the charge. It's therefore not necessary to obtain or exhibit any form of consent from or release by the floating charge holder when selling floating charge assets in the course of administration, which allows sales of assets to be completed quickly and efficiently. In the event of more assets being subject to fixed charge security after the Act comes into force, insolvency practitioners may have to liaise with a larger number of individuals and organisations, obtain their consent and cooperation in relation to any proposed transaction, and coordinate the execution and delivery of any required security releases. Now, more assets being subject to fixed charge security will also impact the flow of funds down the insolvency waterfall and the distribution of realisations. Insolvency practitioners distribute asset realisations from an insolvency process in satisfaction of debts and liabilities in accordance with the statutory order of priority, with debt secured by fixed charge security being paid first. As debtors were able to grant fixed charge security over more of their assets, a larger proportion of realisations will flow out of the waterfall at the first level. Before accepting an appointment, insolvency practitioners will want to ensure that sufficient funds will be available to meet the expenses of the insolvency process, including their remuneration. With less money flowing down the waterfall, insolvency practitioners may also find themselves making applications to the court to disapply the prescribed part on the ground that the cost of making a distribution to unsecured creditors would be disproportionate to the benefits. Now, the distribution of realisations will of course remain subject to the insolvency practitioner being satisfied with the validity of claims and any related security and any relevant ranking arrangements in place. The Act sets out requirements for the transfer of claims, the creation of pledges, and where the assignation of pledges being registered in one of the new registers, effective registration. Insolvency practitioners will need to satisfy themselves that all relevant requirements have been met and any pledge or assignation granted by the debtor is valid. Now, a claim can only effectively be assigned to one person at a time. However, it is possible for two pledges or a pledge and another security right to be granted over the same movable property. In that case, priority of ranking is determined according to the time and date of creation, the earlier created having priority over the latter, or as set out in a written agreement between the relevant creditors. Insolvency practitioners should take appropriate legal advice in order to confirm the validity of security and the ranking thereof prior to making any distribution. As you will see, there's quite a lot to think about, and whilst it may be another year before the Act comes into force, insolvency practitioners should be aware of the changes and consider the extent to which they are required to adjust their practices when the Act comes into force.